here lined up. If I can find her.
I'm here.
I'll see if I can give you spotlight here. Okay, there we go, Yvonne. So you're up and looks like you're ready to go. So Yvonne is a bit of a firecracker. If you are from the Calgary area, and depending on how much gray hair you have, you are probably familiar with her colleagues, Stan Church down in her office, and she's been down there. So again, I'll give a brief introduction on you and then let you kind of finish us out for the evening. So Yvonne was born and raised in Calgary, Alberta. She received her Bachelor's of Business Administration degree from St. XF University in 2009 and completed her Juris Doctorate degree at the University of British Columbia in 2013. She articled with Beaumont Church LLP and was called to the Alberta Bar in 2014. She has received her designation as a Trust and Estate Practitioner through the Society of Trust and Estate Practitioners, STEP Canada. Her practice centers around estate planning and administration, including subsidiary matters such as family contracts, real estate tax planning, and corporate planning. So the floor is yours, Yvonne.
Perfect. And I'm just trying to share my screen here. Can you see this now?
Yep, I see it.
Okay, great. Perfect. Yep, my name's Yvonne Williamson. I work with Stan Church at our law firm, Beaumont Church LLP. So if you like my presentation, give Stan a call. If you don't like my presentation, Stan who? Just kidding. The nice thing about Zoom is that, you know, I can just assume that everyone is laughing at my jokes and I can't see any eye rolls. So I will just pause for laughter when I think it's appropriate. Okay, now to be a little more serious here, I do have to kind of give a caveat to the entire presentation that this is a very, very, very high level overview of the topics that I'm reviewing. Not only are we doing kind of a 3,000-foot overview here, we are doing it in a fighter jet. Like we are going very, very topical and very fast. And really what I'm trying to do here is give everyone an idea and some food for thought. But if you have questions or comments arising from this presentation, you know, give us a call or else call your own lawyer. I am not intending to give you an exhaustive sort of instructive manual here. We would have had to start last year to do that. And certainly this is not a do-it-yourself guide, and there is no substitute for customized legal advice. You need to talk to your advisors about your factual situation. Don't talk to your neighbor. They may have totally different goals and facts. Don't talk to your sibling. Well, I mean, talk to your sibling, but their plan isn't necessarily your plan. All right, so what we're going to do, I'm going to give you a brief introduction to the demographic, social, and legislative context for how we are doing our estate planning in Canada. I'm going to give you a very brief overview of wills. I'm going to give you a very brief overview of enduring powers of attorney and personal directives, and then I'm going to go through sort of some of the additional planning tools for agricultural clients. These are, you know, they are really planning tools for everyone, but they are planning tools that farmers and ranchers and agricultural people use a lot. Okay, perfect. I will try to be brief. I realize that I am the person standing between you and your Netflix. However, I am a lawyer and there's nothing I love more than hearing myself talk, so no promises. Okay, first of all, in Canada, we have an aging population. Canada's population, although this is an old chart, is like an inverted Christmas tree. That is partially because of the baby boomers and everything, you know, that every phase that the baby boomers are moving through is big business, but it's also because we're living so much older. I'm working on an estate right now where the deceased was 105 and both of her sons receiving their inheritances are in their 80s. You know, that changes the whole context for estate planning, because when you're in your 80s, it's not changing your life, right? As opposed to being in your 20s, 30s, 40s, or even 50s, where you could start a business or take more risks. As a result of this aging population, a couple things are happening. You know, one, I mean, estate planning is on everyone's mind because you should be thinking about your estate plan, your parents' estate plans, potentially even your children's estate plans all at once. But also people are looking at inter vivos or the transfer of wealth during their lifetimes because, you know, what's an 85-year-old going to do with money? However, what's a 40-year-old going to do with money, right? Okay, another factor is the wealth that has been accumulated by the older population in Canada. I always give the same example. My grandmother, she's 92 years old. She still lives in her house. She built her house in Kingsland in Calgary in 1958 for $14,000. Her house is now worth over, $600,000. I bought a house 7 or 8 years ago, 2 neighborhoods over. And although, based on inflation and other things, my house might one day appreciate by the same amount, it will never appreciate by that multiple. That would mean that my house would be worth $19 million one day. And I have to tell you, it's not that nice. All right. Whoops. Oopsie daisies. Oh, can you still see my screen? Oh, I just did something really weird. There we go. There we go. Can you see that?
Yeah, we can see that again.
Perfect. I just clicked on something. Okay, another thing that we're considering with everyone's estate plan is divorce rates, right? In the old days, pre-1985, it was very common in a person's will to say, I leave, 50% of the residue of my estate to my daughter, but if she predeceases me to her husband. Now we do not do that. Post-1985, when they changed our divorce legislation to no-fault divorce from at-fault divorce, we have to consider not just what if a beneficiary dies, but what if a beneficiary or the testator themselves becomes divorced. We are, because we are living to be older, we are planning not only for death, but for incapacity. And I will say that, if your power of attorney is 1 page, it probably needs to be reviewed. There's a lot of detail and depth that should be contained in power of attorney and personal directive documents, particularly if you have active business, particularly if you have, a child who's, doing business with you, because they can get themselves in a lot of trouble if it's not permitted, almost like a contract in your power of attorney. Okay. And of course, everyone knows someone who's suing each other over their parents' estate. Unfortunately, because of the increase in value in estates, we're seeing more and more litigation, and farm families are ripe with estate litigation because not only of the values, but also because of the typically unequal distribution between the children. So once again, if you've got a 2-page will, this isn't, it's 2022 here. This isn't your grandma's will. This isn't your dad's will here. You need to provide detail in your documents, and you need to keep them current. Okay. Now, I'm not going to go through all this legislation, but really what I want you to take from this slide is looking at the rate and the recent changes that are happening to our legislation. Even more important to keep your estate planning documents up to date, because there are substantial legislative changes that are happening, pretty frequently. If you just look at everything that's happening in the post-2000s, these are not, minor tweaks to legislation. These are substantial changes and can affect the interpretation of your documents. I often get hired when a lawyer has kind of messed up a will after a person has died. I have to go to court and fix these things, and the change in legislation can be very real. Let's say that. Okay, so wills, jumping into it here. Your will is the document that comes into effect after your death and only after your death. The primary purpose of your will is to appoint a personal representative, that's who takes care of your estate, and to distribute your assets upon your death. There are 2 primary types of wills. That's a formal will, that's what your lawyer would do. Formal wills have to be signed in the presence of 2 witnesses. You have to sign in the presence of 2 other people, typically a lawyer and a legal assistant. Typically like typewritten and contains all that, lawyer and trust language that clients sometimes read and sometimes don't. And the other primary type is a holographic will. So a holographic will is entirely in your own handwriting. It does not require witnesses. It has to be, signed, dated, and there has to be some expression of testamentary intent, meaning intent that takes effect after your death. But other than that, it can say, John's my personal representative after I die, and John gets my entire estate, signed, dated, done, right? It does not have to contain all the usual wills language. I don't suggest doing a holographic will, but I would suggest a holographic will over a will kit. You'll make a mess of your will kit, I promise you. But most of all, I go see a lawyer, get a real will. They're not that expensive. If anyone's had to buy patio furniture lately, you'll realize that wills are the bargain of the century for what you're getting. Okay, in your will, you can make a few different types of bequests. So you can deal, of course, with the personal effects, and sometimes for farm families, the equipment, the machinery, the 1958 Chevy or whatever can be really important to people. You can do specific bequests. So specific bequests are bequests that are limited in terms of monetary value or in what they are. That could include a personal effect, but doesn't have to. It could be $10,000 or your parrot or Bessie the cow if that's what's important. You can create trusts in your will. So a trust, assets held in trust is property that never really vests in the beneficiary. It always unless and until it's paid to the beneficiary. And trusts, as farmers who have the rollover, you have to be very careful about using trust and very careful not to accidentally, take away the ability to roll over assets from your beneficiaries, but they are still possible and beneficial where they're useful. And then your will provides the residual bequests. That's everything that's left. So if you said, I give $10,000 to so-and-so and this quarter section to so-and-so, and then the residue is everything that's left after those two bequests. Okay, I'm going to kind of skip through this. There's lots you can do in your will, right? There is a lot of information, a lot of detail, a lot of specific clauses that can go in your will. If there are any minor beneficiaries, you need to cover those bases. If there are trusts, you need to cover those bases. What a lot of people are interested in is, how do you protect your will? How do you bulletproof your will? Or how do you, make sure that no one can kind of fight over it? Well, number one, you can put a clause in your will that is called a no contest clause. In Alberta, no contest clauses are binding and enforceable as long as they are drafted correctly. Even more reason to go see a lawyer. A no contest clause says that if a beneficiary fights over their inheritance, they lose their inheritance. So that is a pretty substantial hammer. A lot of people like that, right? If there's any discontentment within the family, or if you're making unequal bequests, it looks innocuous, but the effect is substantial. More and more, we are putting clarifying clauses into wills. We're describing, why have I done what I done? And the point there is to, lawyers' notes, if your will was in court or something like that, lawyers' notes are instructive, but put it right in there. Tell the judge the story. Say, if a judge was reading your will, and there's very limited evidence in an estate, and the number one problem that we have in estates is that the person whose evidence is the most relevant, being the testator, has now died. And chances are they told people with their voice and their words a lot of things. Well, that's called hearsay, and it does not help us in court. So having written explanations and documentary evidence, prepared for the purpose of your estate plan, is very, very, very important and very, very helpful, because now the judge says, oh, well, John Smith did this because he was mad at so-and-so, and the other one was, helping him during retirement, and it all makes sense, right? There, now your will's upheld, instead of being, well, why did he do this? Why did John do this? John didn't understand what was going on with so-and-so child, right? Also to that effect is statutory declaration. So those are sworn statements, and I do often encourage my clients to make sworn statements along with their wills if there's any sort of potential for people to question or contest the estate plan. If our clients are elderly, we want to get capacity assessments, just upholding the capacity of the testator to make their will. And Bridget alluded to this, but family meetings are incredible. The family meeting is a trend in estate planning, but don't surprise your beneficiaries. Bring them to the table, talk to them, and make meeting minutes and say, this is what I want. This is why I'm doing it. And they all sign off. It gets pretty hard for them to contest that in the future when they were there listening to explanation of parent or testator. Okay, whenever we're talking about wills, we want to talk about assets that fall outside of the estate. So your will applies to your capital E estate, but that does not necessarily include everything that you own. Any asset in which you have designated a beneficiary, such as a life insurance policy, an RSP or RIF, I know farmers don't like those, but if you had them, and if you've designated a beneficiary, it's not part of your capital E estate. TFSAs with beneficiary designations, pensions, all that stuff. So you can have, you know, the beneficiary designations within those assets, and then the will governs the other stuff. Now, this is not a suggestion to do it. Always consider whether it is appropriate to designate a beneficiary, not just who you should designate, because there are, you know, pretty serious consequences if you didn't consider certain aspects of your beneficiary designations. That's a little bit, you know, outside of our scope today, but particularly with RSPs, which are taxable, you can make a real mess of things. So, I mean, you know, once again, the question is, what are your facts? What are your goals? Excuse me, what are your goals? And then deciding if a beneficiary designation is appropriate, and if so, who it should be. A lot of times my clients leave here and I tell them, and I write them a letter saying, designate your estate as the beneficiary because you'll avoid the risks X, Y, and Z, right? I mean, just on that point, I really like stories, but I'm working on an estate right now where, as a result of a beneficiary designation, the woman had 2 children, they get along, she, you know, everything's perfect. She designates them as beneficiaries in her RSP, and then she does her, you know, will saying 50-50 to my kids, and if either child predeceases me, to their kids. Well, 6 months before she died, when she already has Alzheimer's, her son dies. And as a result, in the RSPs, because her RSPs were a large portion of her estate, what should have been a 50-50 distribution between her daughter and her granddaughter, being the daughter of her predeceased son, turned into about an 86-14 distribution. So the question is, should you, not who should. Also, any asset that is owned jointly with the right of survivorship between 2 people does not form part of the first to die's estate. So this can be a really great tool, you know, between husband and wife, because, you know, the asset transfers automatically upon the death of the first of the 2 spouses to die. However, you know, don't necessarily use joint ownership planning with children. There are a lot of cases coming out about this type of stuff and about what is intended. Is this an advance? All this other stuff. If you're going to do it right, which means see a lawyer and document it appropriately in order to properly you know, put an asset into joint names with a child as opposed to a spouse. It takes about 8 documents. You don't just march off to the land titles office and stick someone's name on there, or your banker told you to, so you figured it was okay. There's many issues with joint ownership. So it can be useful, but always be careful with this type of stuff. Okay. Yes, people like to talk about avoiding probate, and people like to talk about keeping assets out of the side of the estate so they're not subject to claims. That's all fine, but the risks are substantial, and quite frankly, in estate litigation, often everything comes up anyways. So just be careful that, you know, the cure isn't worse than the illness, or whatever the expression is. Okay, enduring powers of attorney. So your will is the document that comes into effect after death. The enduring power of attorney could come into effect during your lifetime if you are alive but unable to make your own financial decisions. So this is your financial decision maker who you appoint in a legal document. If you do not appoint anyone, you have no default decision maker. So the only other alternative, if you have not made a power of attorney, is a court application called guardianship and trusteeship. It is very expensive, it is very time consuming, and chances are you will be incapacitated with no decision maker for 6 months to a year while the court is mulling it over and while your application is sitting in a filing queue, right? So, all right, where am I here? I got a lot of words on this slide. Now, not everyone loses capacity. So everyone will eventually die. Not everyone loses capacity. And if we're all lucky, we will die with full capacity, meaning we will never need our enduring power of attorney. However, this is a planning document. It's just in case. Your attorney has a very broad authority. They can do anything that you can do with your finances, with your assets, other than 3 big prohibitions. Your attorney cannot take property from you or transfer assets to themselves unless instructed in the document. And sometimes there are very good reasons to include a clause like that. you have to, your power of attorney should account for your factual and, foreseeable future. Your attorney cannot give gifts to any person unless they are instructed. Once again, what if you're supporting one of your children? You want to permit your attorney to do that. What if you make regular charitable gifts that you want to continue? If you are making gifts that you want to continue after incapacity, your document should cover those scenarios. And most importantly, your attorney cannot engage in any form of estate planning. They cannot sign a will, they cannot designate or undesignate a beneficiary, and they cannot transfer assets into joint names or out of joint names. All of that is your estate plan, and if you lose capacity, your estate plan is final. Now, your attorneys are, I always suggest that attorneys get some legal advice before they start acting or when they start acting, because there are rights and remedies that accrue in the Powers of Attorney Act, whether or not the attorney knows it. And the biggest mistake that attorneys make is not that they are fraudulent, is not that they are stealing money, it's that they didn't keep proper records and they didn't know the scope of their authority. A big problem is e-transfers when you throw away the receipt, because now you're transferring assets to yourself as an attorney, which is prohibited. So the biggest problem, it tends to be record keeping. So as long as you know what the record keeping is, you can start the right way rather than have to go 10 years backwards with no receipts. Also, if your estate plan is moderately complex, or if you have special circumstances, there's a lot that can and should go into your power of attorney. Let's say that you're gifting the home quarter to, child number 1. Well, what if your attorney wants to sell land to pay for your care? You should put in the power of attorney, you can't sell the home quarter, or sell the home quarter last and only last, right? What if you have a dependent child who's living in your house? Can they be kicked out? Do they have to pay rent now? All of this should go in your power of attorney and should not be overlooked. All right, personal directives. Same idea. If you're alive but you've lost the ability to make your own personal decisions, your personal directive appoints your healthcare decision maker. Once again, it might never come into effect. You might never need it, but it's a planning document. Your agent, has their scope is everything of a non-financial nature. It does not include any authority over medical assistance in dying. That's a very commonly asked question. Medical assistance in dying or assisted suicide requires that if I'm the one getting it, I personally have to have capacity to apply for medical assistance in dying. And at the time when they bring me a pill, I have to be able to consent to it. So for a person who's lost capacity, there's no access to medical assistance in dying because there's no capacity. All right, okay. Once again, I always suggest that a decision maker gets some legal advice before they start acting, because the consequences can be very serious. It's different with personal directives, but there can definitely be some hard feelings that result from, if you have multiple children and you've only named one as the agent and they're making the decisions. The decision to move a parent into a facility is a big one that can result in a lot of hurt feelings if the children aren't all involved. The decision, if heaven forbid that, we're talking about life support or discontinuing life support, those are big decisions. So the personal directive is once again not to be taken lightly. Okay. And of course, if you don't have a power of attorney or personal directive, the only other option is to apply for adult guardianship and trusteeship. It's not your best bet because you have no control over who applies. In your power of attorney and your personal directive, you are legally appointing a decision maker. Whereas if you leave it up to chance, it's whoever feels like applying. Or what if no one applies, right? Two big questions. What if you have 5 kids who hate each other and they all apply? Well, it's stuck in court for years. What if you have 5 kids who hate you and none of them apply? Then the public trustee is potentially making your decisions, right? These are serious consequences. Okay, so moving into some more sort of farm and agricultural specific topics, and I'm just going to remind you again that this is in no way exhaustive. If there was a tax lawyer in the audience, they would string me up by my big toes, because I am not, giving you any of the legal tests. I'm not referring to any of the sections. Now, I'm doing that quite deliberately because I don't want to bore you, and also because I don't want you doing your own tax work. So I'm really trying to hit the high notes here and not drag you down with details. If you have questions, consult a professional. Call a lawyer, call an accountant. Okay, so now this is relevant to everyone, not just farm and agricultural clients. But, the big question, especially when we're dealing with assets like farmland, what are your goals, right? Do you want your assets to be divided equally? Do you want them to be divided unequally? Is your primary goal to keep your farm and your business running? Do you care about fairness? Do you care about legacy? Has this farm been in your family for 6 generations and you want it to continue for 6 more? Is your goal control? That is a valid goal, and some of our clients, their primary goal is controlling people and never seeing assets dissipated. It's a valid goal. It's up to you, but just be upfront about it. If your goal is control, come to your lawyer and say, listen, I want to control people with my money. It's whatever, we're here to help, right? And also, do you have any sort of other special considerations? Do you have a disabled beneficiary? Do you have irresponsible beneficiaries? Is one of your children alcoholic who you want to make sure is looked after? Does your family get along? That's a big one, right? You have a lot more, you don't have to draft as defensively if the kids are all on board. Okay, there are so many words on this slide. I'm trying to illustrate a picture that, I hear from my clients all the time. I hear versions of this story all the time. The numbers in this little slide here are not facts, but what I'm trying to do is show you the difference between 3 different generations, or 3 wealth transitions between generations, starting in, call it the 1920s, 1900s, 1910s, whatever. Let's say that there are 3 generations, and in each generation there are 3 children, and in each generation there is 1 farming child, 2 non-farming children. So generation 1, parents have a farm. Farming child, wants to keep farming, so they go to the bank, they get a loan from the bank, they buy the farm from their parents, and then when their parents die, the estate is divided equally, a third between the 3 children. Now, the reason I talk about income and about what people are paying for their houses is to show how this looks to the non-farming children and to, let's say, outsiders. So farming child buys a farm, 10 grand, whatever. Child number 2, they become a nurse, they move to the city, they buy a house for $14,000. That's my grandma. This, by the way, is my grandma and her 2 brothers. I had to write my grandma's memoirs, and it helped me put some numbers to the thoughts I have. And child number 3, they move off the farm, buy a house, whatever. In the eyes of child number 2 and child number 3, this is fair because their farming sibling is advancing at the same pace, more or less, than they are. Farming child buys a farm, they buy a house, everyone's happy, everyone's advancing equally. Okay, move to next generation. Call it the 1970s. Same idea. Farming child, they want to keep farming. They go to the bank, they get a loan, they buy the farm from their parents. And then eventually the parents divide the estate equally between the 3 children. Once again, children number 2 and 3, they move off the farm, they go get jobs, they buy houses in the city. But you know what? The values of the farm and the other kids' houses in the city, they're all paying for it. They all had to get mortgages, all 3 of them. They all feel like they're advancing kind of at the same rate in life. So there's no perceived unfairness. Let's talk about now, 2020 or 2022, whatever year we're in. Farm's worth $20 million. Okay, the farming child can't afford to, they can't qualify for a mortgage, and they couldn't afford to service it even if they could get a mortgage. So they're not buying the farm from the parents. The parent says, well, hold on, this farm's been passed down to the farming child for generation and generation. So they feel that very strong pull that, well, I want my farming child to get my farm. But the farming child just can't afford it because the value is astronomical. Okay, so child number 2, child number 3, they're moving into the city, they're earning good money, they're buying their houses, whatever. The parents say, okay, well, we can gift this farmland to the farming child by a rollover, or we can leave it in the will. So effectively, farming child is getting a gift of, $21 million. Why did I say 21? Because how many times do farmers come into my office and they say, oh, well, I've got $20 million of farmland going to a farming child. And I say, okay, and then the rest goes to the other 2. And they say, oh, no, farming child needs some cash to operate the farm. So not only do they get land, they get cash to operate that farm. And the other 2 are dividing, other assets in the estate. Well, this doesn't look fair anymore. child number 2 and child number 3 do not feel that they are advancing at the same rate. And looking at it objectively, it doesn't look fair, that's for sure. That's my opinion. And ultimately, you can do whatever you want with your estate. But if you're doing an estate plan like this, you need to protect it, because this is where the litigation comes from, right? This is where these perceived feelings of inequality come from, where the unfairness comes from. And I know farming and agricultural clients are the first ones to say that they'll have $20 million of farmland, and they're the first ones to tell you that they're not wealthy. Well, looking at it objectively, you are. Okay, so now that we've gone through that story, here's a couple super brief concepts, okay, that apply to the farmland and the farm and all that stuff. Capital asset, that's a non-sheltered asset. So principal residence is not, well, it is, but it's exempt. Farmland, shares and corporations, unsheltered investment. So it's an asset that goes up in value that is in some way taxable. Your adjusted cost base is the cost. If I buy something for $1,000, if I buy a quarter section 100 years ago for $1,000, my ACB or my cost is $1,000. Fair market value, that's what you could sell it for on the market. And a disposition refers not just to a sale, but also to a transfer, and also to the deemed disposition on death. So when we're looking at a capital asset, we're saying, what's fair market, what's the cost, and what is this disposing event? Okay, farmers, you have the family farm rollover. So Bridget did touch on this. The family farm rollover is a tax deferral, meaning it's not an exemption from tax or a credit or anything like that. It's a deferral. You're kicking the tax can down the road. If generation 1 bought the land for $1,000 and they use a rollover to transfer it to generation 2 for, generation 2 retains the ACB or the cost basis of $1,000 regardless of fair market value, meaning if generation 2 sells, they have more of a gain. When you roll over the asset, you roll over the tax. It's a deferral. The land and the participants all have to qualify in accordance with the Income Tax Act. Also, we have the capital gains exemption. Once again, Bridget referred to this. The capital gains exemption is exemption. It's not a deferral. It's an asset, and not everyone has a capital gains exemption. Like if me being a city person, I don't own a single asset that would qualify for an exemption. So it is a substantial asset. So different scenario, and of course the numbers are really convenient in my examples because I would have to, take off my shoes to count 20 for you. So, so if I bought my land for $1,000 and it's worth conveniently, 2,001,000, and I sell it to a non-family member, you've got this gain of $200,000. Your tax is half of half, divided by 2, and well, it's up to half of half, so up to $480,000 with the exemption. Up to $240,000. That is a substantial asset. Once again, the participants in the asset have to qualify in accordance with the Income Tax Act. So when we're looking at farm transactions or restructuring transactions or possibly intergenerational transactions, there's a couple pretty common ones. The rollover. And this isn't the family farm rollover, sorry, this is different types of rollovers. Often we are transferring an asset to a person, a human person, an individual, or a corporation into another corporation. You have to take back preferred shares in the recipient corporation. So if I'm a person, if I'm Yvonne the farmer and I have a truck and I have a corporation, both in my own name, I can roll the truck into my corporation, and now I, Yvonne, own a corporation that owns a truck. That's a rollover, right? It requires an elected value, which you have some flexibility in determining. Often farmers are using this for the purpose of writing off depreciation on farm equipment. So you go out and buy all these expensive combines and irrigation or trucks or whatever it might be, and you can't personally take advantage of the depreciation. So you roll it into a company because then you can write off the depreciation. It could also be because you want to, your business has grown and you want to benefit from corporate tax rates. It can be used for estate planning. I know that farmers often have the mentality, and often the advisors, not just the farmers, the tax advisors too, often want to keep land out of a corporation. However, there are some plans that involve rolling land into a corporation. So it really depends on what you own and what your goals are. But rollover is basically transferring on a tax deferred basis an asset into a company. The estate freeze. So Bridget, there's a couple different ways to do this. The most common is with a corporation. Bridget alluded to the estate freeze as well. We do, freezes all day. It's freezing in here, ha ha ha. Your common shares in a corporation. So if I've incorporated a company and I have 100 Class A common shares, my shares fluctuate in value. If I have 100 shares and my company is worth $100, it's $1 a share. If my company is worth $100 million, it's $1 million a share. They fluctuate as the value of the company fluctuates. Preferred shares have a fixed value. They are like debt. So if I have 10 preferred shares that have a redemption value of $1,000 each, they don't change in value. They're fixed. The company has to pay me out on my preferred shares before certain other things and paying the common shareholders. And my preferred share value is always sucked out of the common share value. A freeze is a process of taking my 100 Class A common shares, exchanging them for fixed value preferred shares, and therefore on the transaction date, I have secured all of the value in the company in my preferred shares, and I can bring in new shareholders for $1. So this is often used when we're transferring, doing an intergenerational inter vivos or lifetime transfer, where parents are freezing their shares and bringing in the farming child or the business child or children for that matter. You can bring in a bunch of shareholders. That's the most typical use. There's other uses as well. And there are non-corporate estate freezes. We used to see these, I shouldn't say me because I wasn't born, but in the 70s and 80s, you could do this kind of transaction involving transferring land and retaining like a life interest or a lease that was effectively a non-corporate estate freeze. Butterflies. We're doing a lot of butterflies, a lot more than I would say I used to, not that I've been practicing for 100 years, but it seems like they're very fashionable right now. So a butterfly is a series of transactions where you divide the assets owned by one company or one corporation among two or more corporations. This can be used in divorces. It can be used in purification transactions. So if you have non-qualifying assets in your farming business, you got to kick those out. Usually you would use a butterfly. And it can be used for estate planning. So for example, I have a bunch of minute books on my shelf right here. It's a 6-way butterfly because, five-way butterfly because dad has 5 kids and he wants them all to get a piece of his assets, which are all in one corporation. So rather than having them all own shares in one corporation, he's splitting it during his lifetime into 5 corporations so that he can just say, you get corporation 1, you get corporation 2, 3, 4, 5. It makes it kind of a clean split and very clear as to who gets what. It can also be done after death. So if parent just said residue of my estate is divided 4 ways, the children could undertake their own butterfly restructuring for the purpose of separating the assets into different corporations. Now, there are a lot of other tools. So those are a couple kind of common transactions that we see and do a lot of. But your estate plan is, it's not just your will, it's not just the estate freeze, it's really a holistic, as planners and lawyers and accountants, we're looking at the whole picture of how everything is flowing. So, the use of life insurance, we are seeing that a lot, particularly where the parents are trying to equalize the non-farming children. And corporate-owned life insurance can be a tax-effective way of getting some cash to the non-farming children. Typically involves the use of preferred shares as well. Use of partnerships. Farmers love partnerships. So you're not operating as an individual, you're not operating as a corporation, you're operating as a partnership. Different type of legal arrangement, but very, very popular. Often we're rolling those partnership interests into companies, but what works for a while, and then you pick something else and works for another little while. Contracts. So when you're thinking of your estate plan, you can do a lot more by contract than by will. Your will is a one-way document. You appoint your personal representative. They don't really have to agree. They can renounce, but it's an appointment. You divide your estate. You don't have to get consent, prior to your death as to the distribution of your estate. You just do it. However, a contract is two ways. You're binding the other side. And so you can do a lot more by legal agreement than by a unilateral appointment or a unilateral decision. So you can have all kinds of contracts with your beneficiaries. You can have a beneficiary purchase something for a promissory note, aka no real cash is changing hands, and then you forgive it in your will. You can have options to purchase. If you have gifts or loans or advances to your beneficiaries during your lifetime, you write down what it is. I always tell my clients that even if you get along, even if your kids get along and you get along with them, treat the helper child as though they're your enemy, because oftentimes after the death of a parent, the helper child, the trusted child, the one who helped with banking and driving to appointments, they get treated like the enemy by the siblings. So, write it down, get a contract, be clear as to what exactly you are doing. And if you are doing inter vivos transactions with your children, you need to document it. You can't just be writing checks left, right, and center and not being clear as to whether it's a gift or an advance. There is a case that's been recently decided where the whole issue was whether certain gifts made to the children of the deceased during her lifetime were advances. And it's been 3-4 years in court and it's still under appeal. Contracts with spouses. So for those of you who are fortunate enough to be in your first marriage, only marriage, you might not need contracts with your spouse. However, blended families are becoming more common. Prenuptial agreements, postnuptial agreements, or property agreements. The use of mutual wills agreements are very, very helpful. A mutual wills agreement says spouse 1 and spouse 2 make their wills, and they both promise each other through this mutual wills agreement not to change their will or certain portions of their will. So if you want to provide for your spouse upon your death, but you want a certain thing to happen, even if you're the first to die, after the death of spouse 2, you can do a mutual wills agreement. You can also do that type of thing through spousal trusts, but it's all about, what makes sense in your circumstances. If everything you own is matrimonial property and is owned jointly, you need a mutual wills agreement. You can't do a spousal trust. I think that's the extent of my presentation. Also, the other thing, I mentioned it once and Bridget mentioned it once, but having family meetings, right? Bringing the whole family to the table. Don't make it a secret. Don't surprise people. Don't give people, shock in addition to their grief about your estate plan, but talking with beneficiaries and involving them in the discussion. Even if they're not happy, they'll have a harder time fighting it because they were there, right? They knew what you were doing. You told them what you were doing, and then you wrote it down. All right, so 8:56. I didn't go over time for possibly the first time in my life. If anyone has any questions, I'm here for a couple more minutes.
Excellent timing. I didn't think you were going to get through 33 slides that quick, so you powered through that. So thanks, that was great. And a high level overview there, but I think lots of good information that people can go away and think about and see if they need to do a review on their wills, powers of attorneys, personal directives, and that sort of thing. So just when people are doing that, what sort of events would trigger a review, and how often should these documents be looked at?
Yeah, so I mean, there's no real timeline, but it never hurts to have a second set of eyes or a fresh set of eyes on your documents. So you should be reviewing your own wills, I would say every year. Every year you should, when your insurance comes due or some annual event that triggers you, you should review your documents and make sure that it still says what you want it to say. Every single person, last year I did 118 wills. Every single person who came in here last year doing their wills says, oh, we've been meaning to do this for a year, for 2 years, for 6 years, since our children became 18, well, they're 45. Everyone puts it off. So you need to be reviewing your documents all the time. But, call it every 5 years, have your lawyer take a look. There's usually something worth tweaking. And, even if there's no legislative changes, there's best practices in drafting. the documents we are drafting are not the same as people were drafting 10, 20, 30, 40 years ago. So the practice is evolving, and every time a weird situation comes up or a new case comes out, you know, often we're sitting down and considering whether our precedents should be amended or added to. So frequently in terms of events, I mean, marriage, birth of children, divorce, death of a spouse or death of beneficiaries. You know, if the size or composition of your estate changes drastically, those are all triggering events. I have a client whose 96-year-old father is in a hospice, and he is, you know, on the cusp of inheriting about $24 million. So, you know, that's worth changing your will for, I would say. Yeah, but as your kind of facts change, it's worth taking a look and making sure it all fits together the way it should.
And when should someone look at kind of setting up their first will? At what age? How many assets do you need before it makes sense?
Oh, well, there's so much more to it than just assets, right? Because of the legal decision-making element. So in terms of powers of attorney and personal directives, you're never too young. There is a book I have on my shelf that I can't reach because of my headphones. It's called Willing Wisdom. If anyone is interested in reading, it's a really short read. I think it's like 120 pages, and it's really simple. It's not by any means like a textbook. It's a story. But it, you know, it talks about the exemplary family who started, you know, talking about the family's estate plans and the children's estate plans when the kids were 18, right? If you are out there participating in the world in a contractual way, you probably should have documents. Realistically, most people come in for their first will when they have children, not when they're first married, but most people come in when they first have kids, because then they're like, oh my goodness, I need a guardian. And that really triggers the first will. But, you know, if you're over 18, if you've got some bank accounts, if you know, if you want to choose who your legal decision maker was in the event of incapacity, these are all important and relevant to any adult person. You have to be 18 as a minimum, but it's never too early.
Great. Okay, well, given where we're at time-wise here,